welcome to the International Scientific Conference, Human-Centric AI, Ethics, Regulation, and Safety. AI may not need an introduction, but it certainly requires an in-depth explanation and reliable regulation. Before we begin, I would like to provide some useful information. On the reverse side of your badges, you can find QR code. You can scan it and will have a full program in your phone. As you already know, this conference will span for 2 days. Today is the first day of the conference, and we're starting with a presentation from rising stars in the field, and of course, a great keynote of our friends. We're starting at about 1:15 with a keynote presentation, Human Judge versus AI Judge, the Future of Justice, delivered by Professor Kinga Flage-Gerushinska and Dr. Alexandra Klich. Then we will have 3 sessions, panels. At 1:30, the first panel, AI in Public Policy, Civil Enforcement and Risk Management, moderated by Associate Professor Vigita Vebraite. At 2:45, the second panel on AI in Public Policy, Civil Enforcement and Risk Management, moderated by Professor Assistant Johannas Baltrimas. And the third final panel today, it will be at 4 o'clock, AI, Ethics, Regulation, and Legal Challenges, moderated by Associate Professor Rita Remikiana. Now it's my pleasure to invite exceptional leader and a well-known legal scholar, Associate Professor Vigita Vebraite, Vice Dean of Faculty of Law. Please, welcome.
Good afternoon, everyone. Really, thank you for such a nice words, Neringa. So in the name of Vilnius University Faculty of Law, I really would like to welcome you everyone to this international conference, which is really the second such big conference on AI at Vilnius University Faculty of Law. And we are really happy that we have this 2 days international conference, which is devoted also for young researchers, also for students. We had already nice, very interesting and successful session for students. Now we have for, as you call, rising stars or young researchers. This afternoon is devoted for young researchers, and tomorrow we will have a really interesting also second day of this international conference. So I believe that this is one of the biggest interdisciplinary conference of our Faculty of Law. So we are really happy that we organize it already for the second time. And it's also like a tradition to have it after the birthday of our faculty in October. So I hope we will continue this tradition. So thank you, Neringa and her team, for this brilliant organization. I think all the details are already thought, and we will have also interesting discussions, and we have interesting program and so on. So I wish you everyone good luck and and fruitful discussions. And I think each of us, not only lawyers but also lawyers and scientists and scholars from other fields, will get to know much more about AI and its implications for ethics, regulation, and safety. So good luck, everyone.
Thank you, Vice Dean. Now it's my pleasure to welcome Associate Professor Linas Petkevičius, a leading AI researcher and expert in Lithuania, the president of the AI Association, and a prominent leader in the field, to address us today. Linas, please.
So, dear colleagues from the academia, the participants and the guests, it's really a pleasure to see everyone here in this conference. And what we're seeing, it's really necessary conference, since it's not AI as informatics and the mathematics, it's also about how we apply the new technologies. And when we're talking about the AI, we're seeing everywhere, and nowadays it's really sometimes scary. But one good thing that we really realizing that we are living in EU, where human as a human rights and the human as a centric position in our values is really critical, and we're discussing how the technologies are evolving and changing our future. For us, in mathematics and informatics, we understanding that all the breakthroughs in today's world, AI, as we understanding it, it is the mathematical formula, quite complex, but we could write on the paper. It's really large formula, but it's specific algorithm which doing really amazing things. And we're seeing that the history of AI, from our point of view, from mathematics, is quite long. Even in 1920s, the German scientists, Lenz and Ising, proposed some neural network recurrent model. In 1965, our colleagues from Ukraine was involved by proposing some internal representations by the Lapa and Ivanenko. Our native Alan Pinkus in 1990s and 2000s worked on providing some approximation and accuracies and stabilities of the neural networks which are used in nowadays technologies. But what we're seeing in the last 15 years, it is that all of the breakthroughs are long results of the work in the mathematics and informatics, which accelerated by two things, the open science and the reproducible research. And we're seeing that without those two components, we would not have such amazing things today. Of course, from the AI point of view, we saw a lot of victories from solving problems like beating various complicated games like AlphaGo, or solving some fundamental problems of predicting protein folding by AlphaFold. And now we are all familiar with the mathematical models which are capable to encode the knowledge, huge amount of knowledge, in the one mathematical formula, also known as ChatGPT. We're entering the new era where mathematical formulas now can encode not only the text, but also vision and the sounds around to one gigantic information compression model. And it is amazing, but on the other hand, we even now seeing that some easy jobs are disappearing. If you have some really easy tasks which could be automated, it is changing the complexity of the workforce even today. And many applications touching us today by the AI, from opening our smartphones with the fingerprint or the selfie, it's an AI algorithm, from searching in the Google search nowadays and applying other applications, we not realizing how often we are touched by AI as a service and how it's influenced us even today. So it's quite scary, but in our days, we should see that when we're focusing on AI as a technology of the future, we also look how it in fact as a first human-centric technology. If we will do that, and today you are all discussing how to look and place, strongly place the human in the center position, and it will allow us to have a really strong and safe future within AI. So I really wish a great conference, a lot of discussions, and I would like to wish that a lot of discussions would eventually would lead to really interesting work, which would lead to safe future. So enjoy the conference.
Thank you, Linas, for great insights. And I would like to invite our keynote speakers, Professor Kinga Flage-Gerusicka and Dr. Alexandra Klich.
Dear colleagues, thank you very much for invitation. Vilnius is our second home. I don't know how many times I was here. I want to say that in Poland is the special time because new Ministry of Justice starts a great discussion about new technologies in Polish system of justice in the wide perspective of organization of this system, but also in context of decision-making procedures. My younger colleague has a lot of awards in the competitions for rising stars of law in Poland, so I give the floor her.
Thank you very much. It's an honor to I want to do this like this. To have a presentation today at this university. It's an honor to be a keynote speaker. Together with Professor Flaga Gieruszyńska, we've prepared a quite general, I think, topic, human judge versus AI judge, the future of the justice. And for the past few years, I think that we have seen the rapid development of artificial intelligence technology in various sectors, as it's quickly becoming a tool used in various aspects of life, from everyday applications to complex medical or financial decisions. Finally, we have it also in legal aspects. So since AI is providing itself in so many fields, the question of its place is in the justice system naturally arises. The main question, I think that we are trying to answer on it several times from some quite long time. Can artificial intelligence replace human judge? This question naturally arises. This is a question that stirs emotions and prompts deep reflections on the future to our justice system. A judge not only interprets the rules, but also evaluates the human aspects of each case, empathy, context, motivations. These all things are quite important. But are these human qualities crucial to a just verdict? Or is the objective rapid data analysis provided by AI, the answer to the challenges of today's justice system all over the world? Why is this question so timely? As you can see, because of the problem of modern judiciary, among which should be defined. We can see these delays in resolving cases. In Poland, we have huge problem with this task, with delays in resolving cases, especially after pandemic time. The complexity of some judicial processes, the need of streamlined court procedures, especially in lower value cases or simpler disputes. In this context, AI could potentially speed up the processes and increase judicial efficiency. This efficiency, judicial efficiency, is the keyword nowadays, according to jurisprudence, because everyone wants to have very fast and quick verdict and decision by the court. So in our presentation, which we've prepared together, I will try to answer this question by exploring both of advantages and disadvantages of using AI in justice system. These areas of organization where we can involve AI in justice system, so the area of organization of the work of the courts and the judge. The first one is organizational things and case management. Prioritization also in the field of in-depth analysis of the workload of judges. This can be also used because of changing the way of communicating with litigants and attorneys. So in this organizational sphere, organizational area, we can say about today web portals and in the future social media, which are basically used in some international legal systems. Also talking about this organizational area, we can focus on archiving of large data resources. The second area is procedural. So an area relating of the conduct of proceedings, hybrids or ICT embedded proceedings, also electronic procedural actions. In Poland, since 2016, we have our legislator prepared regulations which allows us to use electronic proceedings in all cases, not only in small claims cases, but only we have prepared the rules, because the system still is not ready. During pandemic time, we were using the system to communicate with professional lawyers, with attorneys at law, with legal advisors. But still, this is not prepared. And in this field, I think that using of AI should be the first point for the countries, for country legislators to use such systems. Also, electronic procedural actions and documentation of the course of proceedings. For example, e-protocol, electronic protocol from court hearings. Also, the new phase of evidentiary proceedings, electronic means of evidence and computer expert, and also computerization of enforcement proceedings. In the area of jurisprudence, I think this is the main thing that we are thinking if AI can replace a human judge, because of analysis of case law and doctrine, and also analysis of procedural material information on the court decision. Sorry for this mistake on the presentation. How we can use this AI in a positive way, because trying to answer the question, does AI replace a human judge? I will do this talking about the next slide, but support systems for the judges' work. We have this semi-automated court decision support systems and fully automated proceedings. I know that in the third panel, we will hear the presentation about using these support systems in legal aspects, but for sure this semi-automated proceedings. So judges uses AI tools to collect litigation material and look for the most pertinent resolution. So this is just this suggestion-based model. AI presents a draft of the adjudication, but the last decision is on the judge's side. So the judge is finally deciding about this. This is also a model based on confrontation, because AI evaluates the draft adjudication, sorry, this is quite hard word, presented by the judge. So still, it's helping, but not replacing the judge. The future, we should ask the question if AI will collaborate or it's competition for AI and human judge. And the possibility of cooperation between judges and AI is quite a natural one. Talking about this fully automated proceedings, that AI eliminates the judge, that AI is deciding and AI itself becomes a judge, I think it's not possible at all, because still we have some ethical issues, some moral issues, some decisions that AI is not able to do it by itself. Of course, we are giving food to AI, asking it for some resolutions, for some answers, but AI, in our opinion, is not able to replace human judge. So talking about the future, cooperation or collaboration, this possibility of collaboration between judges and AI is natural, not only in legal sector. It's in all sectors that we are living, that we are using, that we are working in. So AI is as a tool to assist judges' decisions rather than full automation. But except of the topic of our presentation, I think that this sentence, this rule, can be used in each field that we are working on. It can be actual for medical doctors, for economists, for people who are working with management, some cases or some other things. So it's quite universal one. And these hybrid models that humans making final decisions with the help of AI to gain more objective and speed is something that, in our opinion, we will have. So answering the question, will AI replace a human judge? No. But why? Because this fully replacing a human judge with AI is not possible, first of all, because of emotional and moral complexity. AI, despite its sophistication, cannot understand human emotions, motivations, or cultural context, which is crucial in more complex court cases. Also, because of moral and ethical decisions, justice often requires a judge to make decisions that go beyond dry facts and law. A judge must sometimes interpret laws based on principles of justice, morality, and compassion, which is difficult to program into AI. We can try to make it more flexible, more understanding these moral and ethical issues, but still, I think, maybe I'm wrong, but we think that it's not fully possible to create and to use AI as someone who understands these all things, these moral, ethical issues as human. Of course, we also have some human judges who doesn't understand it at all, but it's more probable that we will find human judge who will use this in a proper way than AI, especially in very hard cases, for example, labor cases connected to the mobbing, or with family cases, or with cases where we have where there is a risk of social exclusion for someone. So this is more probable that AI will help to find some solution than to decide about it. And the other aspect is public trust. We think there is a deep-rooted need in society for judicial decisions to be made by humans with a human perspective in mind. In Poland, we have very specific legal culture. Sometimes we are thinking that we don't have this legal culture, but lot of people are very suspicious that something is planned before, that something is decided before. So how this AI can decide in a very objective way? For sure, it was planned by someone who was preparing or who was trying to use AI instead of human judge of preparing this court decision. So other limitations applying AI to the justice is lack of ability to take into account the context of some nuances of human emotions and morality, these ethical issues. Who programs AI? Can algorithms be trusted or no? Risk of algorithm errors also, and lack of transparency in AI decision making, black box problem. I think these are some disadvantages on which we should focus, but not eliminate AI at all, because I think we all are using AI somehow. For example, ChatGPT, which was mentioned and opening ceremony, we are using it, but not to replace our thoughts, but to be inspired in something. And I think we think the same is with AI in legal aspects. I would like to show you just some examples of using AI in different countries. They were prepared, or there are still some working on these solutions. In China, there is internet courts. It's Hangzhou Internet Court, which is especially for small claims, and it's fully automated. In Estonia, I think Estonia is from the EU countries is the most not flexible, but the fastest in implementing AI in courts, because they have this AI judge project, automation of adjudication in small civil cases. But as I read a few days ago, this program is not used as it was planned to. They are still working on it. They are still trying to make some changes in this pilotish program. Now we have blockchain court in Dubai. So using AI to analyze evidence and automate selected court processes. And I think this is the future. Using AI in evidentiary aspects, with working with evidence, especially this electronic one, is a very good solution, because nowadays we are trying to, and we are gathering more and more often electronic evidence than normal one. Because I'm head of legal clinic in Szczecin at our university. When we were preparing a simulation, court simulation for students, my student prepared brilliant evidences. I thought that it was a real conversation made on WhatsApp and Messenger, but it was prepared. So also using AI, for example, for checking if this evidence is true or not, or if it was, for example, prepared for something. This also is a very good way to use AI. In Spain, Prometheus system, this is a system that's transforming the administration of justice with artificial intelligence tools. So it helps also not only in the field of judges' work, but also in this administrative stuff, for administrative stuff, what is also very important for speeds of justice for court proceedings. And France, predictive justice tools, the use of legal tech to predict judges' decisions. So this also is something which is one step forward, that this tool is trying to help to the judges for predict their decisions. But what's very important for all of us, according to using of AI, AI can make judges and can make all of us to be more and more lazy. So some risk of using AI is that we all will put out our experience that we have, and we will try to replace it by AI. It doesn't matter if we are judges, if we are professors, if we are managers or economists. If we use AI as something that is replacing ourselves, I think that we think that it's not so good. So we have to remember that AI can cooperate with us, but it shouldn't replace us. Thank you very much for your attention. If someone wants to have this presentation, because I saw that you were taking photos, organizers have it, so we can share with it. Thank you. I was on time, I think. Yes, perfect.
Okay, yes, we don't have a lot of time. We are a bit late in the time, so we can start, I think, the first panel, and it's devoted to AI and public policy, civil enforcement, and risk management. We will have 5 speakers, so each speaker has about 10-12 minutes. If you will speak in 10 minutes, so I think we will have time for 1 or 2 questions. I think audience will have questions. Otherwise, we will have questions during coffee break. So the first speaker is Associate Professor Valentas Gružauskas. He is now Associate Professor at Vilnius University, used to work also at Kaunas Technical University. He is a leading expert in Lithuania for AI governance and ethical application of AI technologies. And his topic today is practical management of AI risk strategies for mitigating ethical and safety challenges. So please, the floor is yours.
Okay, good day. So today I will talk more about the technical side of artificial intelligence. So for some of you, you might have a headache, but you will know how I feel every day. So briefly about me. So I have this interdisciplinary background. So I finished applied mathematics in Bachelor, industrial engineering in master's, PhD of management science, taught biostatistics for a few years, had a startup in finance real estate valuation, and now came back to Vilnius University mathematics faculty to teach deep learning and neural networks, like more specifically. So I went through different disciplines, worked with experts in those fields, so have this knowledge from application field in different aspects. So in that sense, we'll talk a bit of a regulation. So about Artificial Intelligence Act, I think there will be more presentations a bit later. But one of the crucial aspects I think is important is standardization. So there is this organization, ISO, International Standardization Organization, that released some of the standards that focuses on artificial intelligence management system and risk management. So Artificial Intelligence Act is more for product certification to receive like CE marking, and ISO is more for organizational aspects. And since conformity assessment is not yet established like in the country with Artificial Intelligence Act, I think it's a good approach to have this initial like preparation and standardization that might help to mitigate risk and fines in the future. So what is this standard about? So it's more organizational, and the first three sections are more of a resources of the organization, the overall strategy, what leadership you have, what support you can provide. It's more about resources, training for the employees, and so on. So this should be like defined in the organization. Then there are more like organizational aspects that are continuously done. So the first is planning to focus on the artificial intelligence system itself. So what kind of product you want to provide, what data sources you will use, and so on. Then we have development of a system and monitoring aspects. So in this sense, data drift concept is quite important. So let's say you have a real estate valuation system, and a few years ago we didn't have energy efficiency class like in the data set itself, and later it appeared, so we need to adjust our system to better adapt to the market situation. So we need to constantly monitor the changes. Then we have systems like evaluation for the test and so on, and how to improve that continuously. So this is aspects from the ISO standardization, and from Artificial Intelligence Act side. It doesn't provide like practical guidelines how to implement it, but there are some reports who recommend how to do that. So one of them is CAP-I, published by Oxford. So we have about 40 questions which you need to answer to help conform with the Artificial Intelligence Act. So if your risk system is low, so it's just good practice. If it's high, well, you need to answer more of those questions to conform. And in the act itself, we have this machine learning life cycle that we have an overall approach of a product. We have a training, evaluation, the operations side, and what we need to do if we decide to shut down the system, how to destroy all the data, and so on. And some of the parts are described in the Artificial Intelligence Act, so we'll comment on some of them. But before I do, I want to focus a bit on large language models, and specifically agent large language models. So talking about artificial intelligence systems and natural language processing, so the computer doesn't understand text itself. We need to encode it into digits numbers, so we can create like a vocabulary of, let's say, all the alphabet, ABC. We have text, and we can convert it into numbers based on the dictionary vocabulary. And that then what the let's say, ChatGPT does? Well, we provide a question and tries to estimate the next word, add it to the question, and then predict the next word again. So it's based on this approach, and it doesn't involve too much like reasoning or other aspects in that process. And about 1 year ago, we have this concept of agent large language models. So what does it do? So we have, let's say, like a ChatGPT, but it can interact with some software or database. Let's say we can ask for sales information, and it must understand that it needs to call this function to retrieve information from the database in this location on this date. So it can interact with some kind of software or application. So it's called like agent large language models. And what additionally we can provide? Well, we can provide the role of the agent. So let's say if it's like a software engineer, you know how to do these aspects. If you are analytical, you can do these aspects. And the better we define this role, well, the more like quality output we can achieve. And OpenAI's CEO, Sam Altman, published this blog post of intelligence age. So he describes how we will have this agent large language models as assistants. So it can be for teaching, healthcare, well, it can obtain a lot of information and provide, well, some insights into the specific problem. So for example, a few months ago, there was a publication published, Artificial Intelligence Scientist. So there were like 5 or 6 agent large language models that interact with each other. So one searches for scientific publication, other writes the publication, another makes software and calculation, and you can create like 10, 15-page scientific publications for about $15. It's not high quality yet, but it's the initial process, but technology is moving to that side. A month ago, NotebookLM was published by Google. So what you can do, you can upload your book, your presentation PDF, and it can generate a podcast, like 2 people are communicating together. So you upload the PDF, it asks like what kind of 50 questions I could ask about this. You get the questions. It says, well, answer these questions based on that document, reformulate the answers, well, like I'm talking in an interview, and then create, well, sound from that task, and it generates like 20 minutes of speech. So maybe next year I won't need to do the presentation, we'll just send the PDF, and, well, you can listen to that. And more these agents, what can do? So they started some of the tools to publish online. Like I have this task, I need to accomplish it. So we have this like payment process, and human, well, can make the solution, submit the agent, and then can evaluate, make the payment, and tries to interact with the physical environment. And because of this like growing, well, connection to the virtual physical world, we have a different risk related to that. So for example, with my colleague Miroslavas, he will present next, we have this project testing chatbots for social services. So let's say to consult unemployed, and I write like, I'm 60 years old, I lost my job, divorced, have 2 kids, what I can do, and that large language model calculates statistics and says, well, it's better to commit suicide than try to do something. So it's a bit of ethical issues from that. So in this case, I'm a bit joking, but let's say if I'm unemployed, then I want to change profession. So maybe in Lithuania, there's a lack of a truck driver, so the system will recommend to be a truck driver. But it's not necessarily beneficial for the individual. And it's a bit difficult to test that because it's not like we have a question answer. In this example, we might have like 20, 50 answers which leads to that recommendation. So it's very difficult to test that. So in large scale, well, tools like this, there are a lot of risk related to that. So I will skip a bit of that part and want to touch a bit of explainability. So one thing is to test for these scenarios, and another aspect is for black block models that we need to have some explainability from that, a bit of necessary aspect. So, for example, if we have credit risk monitoring, we can have this called tabular data explainability. So in the middle, you see the average default risk, and on the left, different variables for a specific application that company or person submitted, and we can see how the default risk change. So it's a bit of explainability aspects. Another example might be for image classification. So let's say in this example, my goal was to classify wolves from huskies, and this is like the goal of a product. But when I created the model, I made the explainability, and I saw that if the background is forest, it will be a wolf. If the background is grass house, it will be a husky. So the algorithm didn't learn to classify the animal. It learned to distinguish the background. So it will be like a non-conformity with the Artificial Intelligence Act. Okay, a bit of skipping. And because of these, non-conformities, we can have some risk related to that. From the company side, let's say we have non-conformity, and the government says, well, you need to fix it. So let's say ChatGPT, when was trained on electricity, they spent about $10 million to train from scratch the model itself. And let's say we have a legal situation that the person's name or surname was trained on the model, or some book was trained, and due to copyright, we say to remove it. And you cannot retrain from scratch because it will require a lot of expensive. So we need to fix this issue without retraining fully. So there are scientific publications and methodologies how to solve these issues. This is just one of the examples, but in general, I just want to emphasize that depending on the non-conformity, there will be a lot of legal cases from the government company side, how quickly to do that, what expensive, how to solve it, and so on. Because we cannot have this how to say, if statements. Well, if this user complained, then if the output will be like this, do this. And if we have 10,000 complaints like this, so it will be like if. So we need to improve a model from the fundamental aspects to not repeat that error again. So to solve these issues, there will be, difficulties to do that. So from my side, that's it. I started about these issues to write weekly newsletters, publishing in LinkedIn. So if somebody is interested, you can follow me and connect with me. So thank you.
Thank you very much.
So questions later? Huh?
Yeah, later.
Okay.
In the coffee break or later. So the next speaker is Associate Professor Miroslavas Seniutis. He is Associate Professor at Vilnius University Faculty of Philology, and his interests include the design and use of digital technology in the practice of social work, ethical application of artificial intelligence for social good, with particular focus on the empowerment of vulnerable groups. Am I right? Yes? And his topic is exploring large language models and social service delivery, initial results of a systematic review.
You could see the start of my talk, no? Hello, everyone. I am Miroslavas Seniutis. I am a researcher and teacher at Faculty of Philosophy, actually, not Philology, at Vilnius University. And it's an honor for me to speak here in front of you. Today I will share with you findings from the systematic literature review, which we done together with my colleagues, Arturas and Valentas, who has just spoken before. My presentation is titled Large Language Models in Social Service Delivery. The aim of our review, sorry. The aim of our review was to analyze academic articles on the use of large language models in social services, especially focusing on opportunities and risks for several areas, mainly for organizational settings, for the professional activities of social workers, for their identity, and for client groups, social service client groups. We manually screened over 1,300 abstracts and articles and titles, from 3 databases, Web of Science, Scopus, and EBSCO. We assessed 97 reports for inclusion criteria, and finally we included 34 studies for qualitative analysis. The key findings of our review focus on 3 main topics: opportunities of large language models, risks they pose, and steps and measures needed to reduce those risks. So regarding opportunities, reviewed studies show that the use of large language models enhance certain managerial processes within social service organizations. For example, on the one hand, these models reduce costs, unfortunately, by reducing personnel who deal with simple and administrative tasks. On the other hand, these models help with staff shortages in social service organizations, especially in mental health and elderly care, sectors where, as you probably know, staff shortages and work overload are a critical issue. Finally, natural language processing techniques and methods are used for analyzing client data and improving how services are planned and how organizational resources are distributed. Studies also show that large language models help social workers in their frontline practice. For example, for administrative tasks, these models assist with emails writing, taking meeting notes, drafting reports. For analytical tasks, those models help process text, classify, organize content, summarize. For specific professional tasks, large language models help create case assessments, develop assistance plans, and so on. It's interesting that large language model-based chatbots can act like supervisors in helping process, and by giving feedback on goals, challenges, or progress by both clients and social workers. Additionally, reviewed studies show that large language models help better meet the needs of specific client groups. For people with mental health issues, large language model-based chatbots help identify and reduce certain symptoms like depression, anxiety, stress. They can also direct the client to the right support services. For youth and children, a large language model-based chatbots help improve social interactions, socio-emotional skills like listening, dialogue, self-awareness, decision-making. For elderly people, these models help reduce dementia symptoms by providing suggestions on different mental and physical activities. They also support independence of elderly people by assisting with tasks like paying bills, shopping, etc. Reviewed research show also certain limitations and risks posed by large language models. One group of risks could be relates to limitations in large language models' outputs. For example, these models often generate human-like responses, but they lack of understanding what they generate. And these models also struggle to maintain context during longer conversations with clients or with all users. Additionally, these models can reinforce biases, particularly related to gender, to disability, to race, and these are critical factors for clients who belong to vulnerable groups. And finally, large language models usually do not provide clear explanations of how they work and how they construct, how they generate suggestions, answers on our questions, or sometimes even decisions. And this lack of transparency may lead to lack of trust and to accountability issues. Another group of risks can be categorized according to diverse groups of users of large language models. For clients, these models usually do not consider body and body language and emotions. This makes it difficult to communicate with people who have speech or thinking difficulties. Regarding social workers, large language models are good to assist with, as I said before, administrative tasks, with paperwork, but they are still not good to give advice or making decisions in complex clinical situations. For students, students have trouble using large language models because they lack of real human connection using those models, and often they have technical issues using models or simulations based on large language models. And these tools also allow students to avoid deeper learning by providing fast and short answers, outcomes. And finally, let's see briefly what measures should be taken to mitigate these risks posed by models. So firstly, more investments are needed for research and development activities to improve existing models and to create specialized models designed for specific tasks, specific organizational contexts, specific target groups, specific users. Secondly, to ensure these models align with ethical standards, it's necessary to involve different stakeholders. In this case, developers, social workers, social service clients, managers of social service organizations, social policymakers. So all of them should be included and involved throughout all system life cycles, from beginning, from model system planning, design, through development, deployment, and till use and assessment. Additionally, ongoing AI literacy trainings and courses are essential for social workers, and learning prompt engineering could be very useful to help social workers to use these models more effectively. And finally, general regulations like ethical guidelines, policies, strategies are needed and should be continuously updated. However, more important topic is specific regulations such as standards, instructions, practical guidelines, code of ethics for different professionals involved throughout all stages of life cycle of AI system. So all these specific regulations must be developed, and it's important to create specific methods and tools to develop those regulations. And this could be addressed by interdisciplinary research teams. Thank you for your attention, and see you later.
Yes, thank you very much. So the next three speakers will be from the field of law. And the first speaker is Dr. Viltė Kristina Desers from Leuven University. Yeah, you are here. She actually defended her thesis at Vilnius University and now lives and works in Belgium. Yes, and her topic is AI and AI Act, Challenges and Opportunities for Justice. So please, the floor is yours.
Hello, everyone. Pleasure to be here. I don't have a privilege of living in Lithuania now, so I'm always very happy to be back, and especially for such a nice reason. Thank you very much, Neringa, for the invitation. I was genuinely very excited to accept it. And another thing I'm very happy about is that seemingly people who are presenting today, we share some ideas, and I think that I'm very much looking forward to the discussions afterwards, because it's very good to have presentations that connect to one another, because it means that we can really have the conversation. So without further ado, I would like to delve into my topic for today, and that is specifically the use of AI in courts, and specifically chatbots based on large language models. I don't have a technical background, but I'm very happy that in the room we have people that will absolutely correct me if needed. So that is also reassuring that we can come back to technical details if necessary. So what I would like to discuss is a very particular question, and that is the use of AI in courts, specifically chatbots based on those models. I will call them LLMs to shorten it. Is it limiting or enhancing access to justice? The limitation for lawyers is important, is that I am addressing European legal framework. That is important to disclaim. Just very briefly, for those who do not have technical background, I would like us to agree on a few technical definitions in very simple terms. That is, when we talk about generative AI, we talk about a form of AI that generates new content, for example, text. When we talk about generative AI chatbot, we talk about a program that simulates human conversation online using that generative AI. And the large language models, they learn to predict the text based on the next best word or phrase after being trained on very big, large amounts of text. So that is background information that we have to keep in mind. And to set the scene, a few things should be noted briefly. All of us know that AI entails benefits for the justice system. Those were addressed by keynote speaker. It provides access to legal information to those who normally would not have access to legal advice. So it increases access like that. And then there are, of course, efficiency savings of costs. Yet many notable scholars, of course, are warning about the dangers of using these technologies. And to avoid pitfalls of generalization, because that is something what we hear a lot, and sometimes we do a lot, we just generalize and we discuss AI in abstract. But no, there are many different applications and they have many different implications, and we have to be specific when we discuss it. So there is no exhaustive list of applications that are used or can be used, but scholars are mapping them, making the list. And also the European Commission for Efficiency of Justice recently also launched a database to track these systems. So you can always check it up there. Broadly speaking, I will classify them as those that are dedicated for information processing, such as summarizing, retrieving information. Others that are used for creative tasks, such as drafting, reasoning, judgment, and also, lastly, the predictions for the future. And as mentioned, our focus will be only on chatbots. We cannot discuss in abstract everything. So we will discuss chatbots, and they, as such, they have various issues. They have issues of helpfulness. They're not necessarily helpful. They are hallucinating because they can provide non-existing facts or inaccurate facts. They have lack of interpretability, as explained by previous speakers, and they can also include offensive, biased content. But aside from all these problems, we will focus on one thing specifically, that is interplay with access to justice and the right to fair trial. And if we talk about the right to fair trial, about two particular elements. These will be independence and impartiality of a judge as an essential component of the right to fair trial, and secondly, adversarial proceedings. So as you see, we're narrowing down. Okay, we're only talking about chatbots, and we're only talking about these specific guarantees, as I think we can only make conclusions if we are specific enough. First, a few cases to illustrate the appeal, the temptation to use chatbots and the increasing use of them. Recently, in 2024, there was a public storm after revealing that a Dutch judge used ChatGPT as a source of information for the ruling. What did he do specifically? He asked a question for a judgment in a legal dispute between two homeowners to determine the average lifespan of solar panels. And later, he reproduced that part of the generated content in his verdict. Other examples. Earlier in 2023, a British judge admitted that he asked AI tool to provide a summary of an area of law and received a paragraph that he felt that was an appropriate answer. Another example, in the US, two lawyers were fined after they used fake citations generated by AIs. Chatbots simply invented the cases that did not exist. Further examples, Colombian judge admitted that he used ChatGPT in the case that concerned autistic child's insurance. So to decide about a sensitive case concerning a child who had health issues and his financial situation, the court just resorted to ChatGPT. And the last example concerns Indian judge who used ChatGPT in a criminal case and sought for advice concerning the criminal penalty. And then, so here we talk about general chatbots such as ChatGPT, and then we have the specialized ones, such as developed by LexisNexis or Thomson Reuters. These are those who are specifically trained for legal research, and there are plenty of them. And here, notably, the information can also be false. It may look appealing because we see these big brands, coming from big companies focused on legal research, and yet they're not accurate. And the recent Stanford study, published by, written by Stanford professors, multiple of them, in 2024, revealed that research tools made by LexisNexis, Thomson Reuters, each hallucinate more than 17% of times. And these companies claimed to have resolved that, but there was no empirical evidence to prove that that was actually resolved. And other examples of tools, not from these companies, but others, sometimes they're only correct 18%, 1/8, not 80, but 1/8, 18% of times. Only this amount of times they provide correct information about legal facts. And this is then the tool with which judges communicate, right? And attorneys communicate. So I will provide you main types of hallucinations. So they can be unfaithful to the training data, those tools. They can be unfaithful to the prompt, to the question. They can be also unfaithful to the true facts of the world. So the facts can be also twisted. They can make up case law that does not exist. They can give correct answers, but provide bad reasons. And you know that for law, correct reasoning is the essence. What we cannot do in law, we cannot have result-based reasoning when we have the result, and then we just come up with arguments to justify that result. This is what they do. And they can also give incorrect answer due to bad source, because they have inputs from different jurisdictions, different statutes, different courts. They also have input of the judgments that are later overruled, right? They're changed eventually. And on top, many of them are largely focused on the United States legal system for now. So last but not least, they have a tendency to agree with the user. So they have also bias towards the answer that was raised by the user, and elementary errors of reasoning. And then let's look closer, what does it do to the right to fair trial? So I will not go into the lawyers will know the background of these guarantees, but I will be very brief. When it comes to, imagine that a judge is using the stool, or the stool would replace a judge, or at least a thinking process. But we have the requirement of independence, which means that judge should be independent for any influence, be it private or public, has to be impartial, has to be no bias to either party, both in mind and how he appears. And then it becomes problematic because the developers who are developing these tools, they are mainly private companies. There can be various interests involved. There are biases in the data that they use. There are hallucinations, and there's also an automation bias. If judge uses this tool, he can think that the result will be better, or that he will. There's so-called automation bias, which means that judge will be leaning towards the output suggested because he will trust the system, and then the traditional critical thinking process is affected, which is necessary. And this is also the reason why these tools are classified as high risk in the Artificial Intelligence Act. So it should be noted that the use of such a system with all the fallacies that I have just discussed, with the biases ingrained, it casts doubts, it can cast doubts on the impartiality of the judge, just because of the very fundamental components of the independence of impartiality of a tribunal. And then let's look into another major, essential part of the fair trial is adversarial proceedings, which means that the party has to not only be able to know all the submitted materials to the case, but also to comment about them. And here we have a major issue of explainability, also addressed before. The information that would be provided to the case, it would be very difficult, I would say even impossible in most of the cases, to have a proper explanation why the tool has reached certain conclusion, because they do not perform or understand legal reasoning, but instead they work with correlations between pieces of text. They do not provide answers from authoritative databases. They instead generate new text using an algorithm based on the prompts that they received. So this means that it is just a likely combination of the words based off the words that the system has, but nothing more than that. There is no reasoning involved. And so they are just language models. They are not knowledge models. And they are, I would say, they're mere next text predictors. And this is a completely different thing than that we need in legal proceedings, where you have to provide an actual reason. So just by definition, you cannot expect that this criteria will be met. And then you have another layer of complexity, that you have different players involved. There is an explainer, let's say someone who knows the AI system. He can explain how it works in his own terms. But then you have the explanee, the person who will not necessarily understand what is being explained. And then there are the hallucinations that I discussed before, and then information can be also withheld due to various interests, such as intellectual property, protecting how these algorithms work, trade secrets, or risk of data manipulation. I will move to very brief conclusions now, but first I will just say that we see a lot of policy and regulatory initiatives saying that we will address that, we will solve that, and European Union is very loud about being the leader in regulating artificial intelligence and providing solutions. But when we look into, for example, ethical charter on the use of AI or EU AI Act, what we see there are very abstract provisions, such as we have to provide access to data, everyone should be able to review data used, and everyone should be able to understand the results, the outputs. But how do we enforce that in practice, right? We just, made these abstract declarations, but it is not actually feasible to expect that just because of these principles enshrined in these documents, that we will actually be able to enforce that and to get the result that we need. So to conclude, there are evident challenges that arise because of use or potential use of the chatbots. And this is regardless of the output. Even if the output would be right and good, let's say correct in a particular case, process matters. And the right to fair trial and access to justice, it's a procedural right. We need the right process too, even if result in the end will be fine. And due to numerous challenges and fallacies that I mentioned, the output of chatbot cannot be accepted as evidence, just cannot. Yet it is unreasonable to expect that all the interested subjects, judges, attorneys, parties, that will not rely on it. Now we are talking really about the question of extent, how much they will rely on it and how do we have to regulate. Current policy regulatory approach, nice but not enough. And there are various solutions discussed. What can we do about it? So from technical solutions to do technology right by design, I don't think this is feasible. They're suggesting to involve legal experts in the development of technology. They're suggesting that there has to be legal literacy for computer sciences. There's a huge AI and computer science and legal community working on that, scholars in the world. And if there is one thing that they agree on, is the digital literacy for lawyers and vice versa, that this is something that we should just increase the awareness of what is happening, and because of that we will do everything more carefully. But there are no quick solutions to what we face now. We cannot exclude that better models will be developed in the future, but for now it is what it is, and it is very problematic, at least in the light of access to justice. Thank you.
Thank you. And the next speaker is from Vilnius University. She's a PhD student at Vilnius University Faculty of Law. Her thesis is about insolvency law, and she will speak. It's Lina Dzinselataitė-Šaltė, and she speaks about AI empowered insolvency from the creditor's perspective. I need help. How to make it through the whole screen? No? Oh, thank you. Thank you very much. So, good afternoon. Such a great audience. It's a pleasure for me to share my thoughts after such great presentations with deep analysis, very important aspects of it. And I guess my presentation is from the quite a narrow perspective, but still touching, I think, I think so, quite one more dimension where AI solutions, tools are necessary to be discussed. And this is the insolvency and particularly creditors' perspective, and particularly unsecured minority creditors. Why creditors? And because my topic, my research topic is on insolvency law everywhere, and starting to talk about objectives of insolvency proceedings, about the main characteristic of proceedings, about the principle. Everywhere we meet creditors as the maximization of creditors' recovery, as a collectivity, meaning that the insolvency proceedings change the individual enforcement processes to the collective actions of creditors, as the main principle is the equal treatment of creditors, having substantive and procedural dimensions, also requiring not only the equal share of recoveries, but also equal rights for creditors, and the efficiency principle also requiring payment to creditors will be as quickly and as fully as possible. And what is the problematic in insolvency proceedings with those creditors, unsecured minority creditors, that they still receive a really low part of the claims to be recovered. Naturally, it leads to the lower interest for the participation in the insolvency proceedings, which makes the distinction between secured creditors, big creditors, between and unsecured creditors, which I think that leads to like not covering the main principles, the main aim of the insolvency proceedings, and undermining, I think, that fundamental principles. And what what challenges those creditors, unsecured minority creditors, to be in that position, that they, despite the fact that the low recovery rates are, they are also cannot share expertise. They need to understand the process, to understand the proceedings, to understand the financial, to understand the business of the debtor. They do not or do not want usually to spend time sufficient to go deeper into the insolvency proceedings. They are in, of course, this leads to the third factor, that participation. If you, of course, every creditor could participate by asking experts, to lawyers or accountants to analyze insolvency proceedings they are in, but this requires money, and this factor is one of those stopping them to put the effort. What we have now, talking about the current e-governance solutions, we have to mention that the Lithuanian example, we have insolvency processes information portal. All the information about the proceedings, almost all the information is in that portal. Every creditor can join and see not only the statistical information, but also financial information, assets of the debtor, can provide a claim in that system, can follow the organizational information when the creditors meetings are being held. Even the communication option is for creditors to interact with each other, and also with other parts in the proceedings. We have insolvency guide as a tutorial for a debtor or a creditor, but still this is the Lithuanian example. When we're talking about the AI-powered tools in the market, researchers shows that there are tools used by financial institutions, by service providers, as legal firms, accounting, and other financial services providers. They are using already in the market created AI tools. They are adapting for the business of creating new ones. In academic circle, there are also options provided for for one particular problematic to solve, but still what I see is missing, if I can say so, when we think about creditors and secured minority creditors, that those tools I've mentioned before, they are very welcoming, but still I do not know whether they are enough to minority unsecured creditors who do not have such a free hands to use those tools. Even the same insolvency portal, which provides even the financial information for the creditor who's not using the same tools to have the same understanding on the proceedings and the situation and the proceedings as the bigger creditors has. So despite the biases, the risks, all the so important aspects mentioned in previous presentations, still I think that we could think about some kind of solutions for those parts of participants in insolvency proceedings, providing them communication tools as the same chat bots, at the same time solving and minimizing risks, indicated maybe providing AI, thinking about AI avatars who could help even especially in those situations when we have proceedings without even insolvency practitioner. Now we have a proposal on EU level where the proceedings are offered to be in small cases, but still without insolvency practitioner, meaning that with no neutral person administrating the proceedings. At the same time, thinking about solutions helping to analyze information, or even to help generate documents for the creditors to properly represent the interest. So despite those risks and challenges indicated, what I see that from my perspective, from my dimension, that in this case we have to understand that the government participation is the main point where this particular question can be solved. And what other risks from the creditor's perspective is that they, of course, too free hands, too much options too many options for the creditors to help themselves can become an abuse for those opportunities they are given, and the same lead to the expeditiousness. Interfering to the expeditiousness of proceedings. So to conclude my presentation, I would say that still the process in digital solutions is significant and already existing, but and at the same time protection of the interests of creditors with the small unsecured claims is not necessarily sufficient from my opinion, and the government involvement should be essential in this case. So thank you for listening. Thank you very much. And the last speaker in this session is a guest from Latvia, from Riga Stratens University. This is Liga Svempe, and her topic is regulatory framework for AI governance in medical devices.
Thank you. Yes, so hello, my name is Liga, and I'm a PhD candidate from Riga Stratens University in Latvia. And today I'm going to talk about AI governance in medical devices, particularly in digital health devices, and also I'm focusing on European geography. Yes, so just a little bit of the background. So there are two aspects to explore here. So first of all, the Medical Device Directive was, okay, and I'm going to focus not only on the AI Act, so no worries that I'm talking about other directives. So Medical Device Directive was adopted in 1993. So imagine that was 90s, last century, and then think about the technological advancements then, and then compare it to what we actually have nowadays. So you will agree with me that the changes are very, very significant. The other aspect is the actual quality and the oversight that was ensured under this directive. So there was a Harvard University research done which compared American medical devices with European devices, and it showed that actually those devices that were confirmed or certified as European first, they actually had more risks, and they experienced also more recalls in the market. And there were also several scandals in the past decades here in Europe. The most notable is the poly-implant prosthesis scandal, where the manufacturer used actually a very low-grade silicon in the implants, which put at risk a lot of human lives. So these two aspects come together, and in 2017, Europe adopted a new regulation, medical device regulation, which introduced new requirements, more stringent requirements for the development, for the quality assurance, and also for the clinical evaluation, more trials needed, more evidence needed, as well as for the post-market surveillance. And it was all for the overarching goal to ensure the patient safety and also for the transparency of these devices. What this regulation also brought was specifically, in the first time in Europe, it defined what is the new concept or the software as a medical device. Previously, FDA, Food and Drug Administration in the United States, and also the International Medical Device Regulatory Forum, which covers the whole world, they had a definition that the software as medical device is a software for a specific medical purpose, which is not attached to a hardware. So in this regulation, also the definition covered that medical device means any instrument, apparatus, appliance, and software. So I specifically highlighted that it is also a software here in the definition, which is for human beings and for one or more specific medical purposes. And I want to stress this, that it is for a specific medical purpose, because I will come back to this definition at the very end of my presentation. So just to give maybe a better impression of what I'm talking about, nothing so difficult, but basically here I put 3 examples of 3 softwares as medical devices. Disclaimer, I don't have any financial gains here, so it's not an ad, just 3 various examples. So basically, this is like an app that you download on your phone or tablet, similarly as I know Facebook, Spotify, or Instagram, but it's basically, this app has undergone a medical device certification, and that it can help you for your any kind of health issues. So for example, the first one, Kaya Health, it comes from Germany. It is intended for back pain, and it gives you exercises, and then when you perform these exercises, it employs a computer vision, and it tells you if you're performing correctly these exercises or not, and it can give you advices like maybe to bend lower or not to bend so much. The cardio signal, another one, this is a Finnish one, that is a heart disease detection using their app. And the third one, okay, another disclaimer, I've worked at that company, but again, I don't have any financial gains there, but it was a digital therapy tool for stroke patients, and it included functional therapy, so again exercises, it included cognitive behavioral therapy, and also an education. So far so good. But are there any implications for this regulation? Unfortunately, there are quite many. I listed them here, but I'm not going to go into details here. But basically, overall, it means more cost for the manufacturers. It means also delays in product launches. Maybe some of the manufacturers decide to actually leave European Union for other regions. What I circle here is 2 that affect digital intervention. So first of all, the classification issues. Compared to the previous directive, most of the softwares as medical devices, they will be up-classified. So from the first low-level Class 1, they will, most of them, if not all, will be actually Class 2 devices, which means that the manufacturers have, again, more requirements, and they actually need to involve also notified bodies. It means more financial resources and definitely longer times to actually access the market. That is the one thing. The other thing that I'm going to focus more here are the constraints on software updates. So as you can imagine, software, it's actually constant updates. I don't know, you can check any app, take for example Spotify, it most probably it has weekly updates, and then they give you something new again. But what is for medical devices, it's actually way much difficult. So the regulation states that any substantial changes, either quality management system or in technical documentation that actually changes the product, it needs to be recertified, which means that again the manufacturer needs to undergo the whole certification process, which can take months. So, and then imagine a regular non-certified app that can actually launch updates on a weekly basis, that it seems like an unfeasible thing for these softwares. But then the question is about significance, like what is significant update? Unfortunately, here the regulation or any guidelines do not give us any answer, and it's basically there's quite a room for interpretation. The only one thing, the only document that I pointed here out is from the Medical Device Coordination Group. It is not legally binding, and it's more like a consultation or a suggestive document, and it also is focused only on one specific this transitional provision, and it also states that it's not applicable for regular certification process or recertification. But again, just to give an example what it means and how it actually defines this significance, and I circled here that change of algorithm is considered as a significant one. So then imagine any medical device or digital device that also has AI within it. It basically, any changes can fall into the bracket of significant changes. So when the AI Act was somewhere in the air, probably some thought that it will help to understand better, so what to do and what not to do, and when it needs to be recertified. Partially, it gives answer, but not fully. So first of all, any of these softwares fall into the high-risk category because these are medium or high-risk devices. Then according to the Act, they are high-risk devices, which means, here I copied from the AI Act, but basically I want to point out the last paragraph. So for these systems that continue to learn, so if you put more training data and continuously update, if these changes are predetermined, then these are not classified as substantial modification, so you don't need to undergo, again, this lengthy and expensive recertification process. So good thing. Unfortunately, maybe I can say unfortunately, again, we don't exactly know what means this, how to make this predetermination. So again, it's left on the consideration of the manufacturers and also the notified bodies here in Europe. And another perspective also from the notified bodies, here's an example from Germany. So it is an informal checklist, but it also mirrors the same attitude towards the process of, and basically towards these continuously learning systems that if they don't exceed a certain level of changes, then they should not be recertified. But again, maybe in this case, we could take an example also from the United States, from FDA, as they are also thinking about how to regulate these AI systems in medical devices. And then one of the solutions is also this predetermined change control plan that should be implemented in these manufacturing companies, where they set what is this, this level of changes that are predefined. And the last slide about the generative AI, nothing much to say maybe or to discuss here, but I still wanted to touch upon it because it's quite on a hype. But how to regulate this is still very unclear. And here I want to go back to the definition on the beginning of my presentation. So a medical device is developed for a specific medical purpose. One narrow purpose, one diagnosis or one therapy, and etc. But when we see like how generative AI works, then we understand that the scope of it is way much wider. So there are a lot of questions still unanswered. And there is one interesting suggestion. It was by Harvard University professor and Google Health expert. They compared the generative AI with human doctors. So the same way that human doctors learn, and then they pass exams, and then they repass these exams and recertify them, generative AI could be actually looked the same way. So they get training data, they get trained, then they should probably pass an exam, and then they should be recertified again from time to time. So interesting way to see that probably generative AI could be certified the same way that human doctors. So yes, thank you. That's from me.
So thank you very much. We really don't have time for questions, so I think all the questions will be during coffee break. So please, now it's time for coffee break. 15 minutes? Yeah, 15 minutes.